Hello, welcome to today's immigration tidbit. Okay, I'm assuming he got the green card through you. I'm assuming you're either a U.S. citizen or lawful permanent resident and he married you. You're stating that he went to India and spent 5 weeks with his Indian wife. The U.S. law is such that one cannot commit bigamy, or if one marries more than one wife, one is committing bigamy. So, two things: committing bigamy, and it means that your marriage technically is not valid. So, if that's the case, and you are asking me basically what to do, number one, you need to get an order from the court. Invalidating the marriage, although it's not valid to start with, because if he was already married in India and did not get a divorce and it was a legal marriage, then by marrying you, it can't have happened legally. Secondly, if he got the green card because of his marriage to you, since the marriage didn't legally exist based on these facts, you would have to notify immigration of what has occurred, with sufficient evidence and so forth. Obviously, they can't just take your word for it. They're going to need documentary evidence and so forth. But that would be sent to immigration, and then immigration would decide whether or not to put him in removal proceedings, and or initiate revocation proceedings for the green card. I mean, this is a good example of where revocation would be appropriate, because the only basis that he got the green card, assumably, was through you, through marriage, and if the marriage didn't really exist, then he should not have had the legal opportunity to get the green card. It would be ICE that it would be sent to. And again, it cannot seem as though it's a letter from a wife who is trying to get back at her husband for seeing some other woman in India. I mean, obviously, there needs to be a coherent timeline and evidence that he married his wife in India. He did not get divorced. He then married you afterwards, and that, of course, will show that the marriage is not valid. Okay.